You may have heard that if you refuse to give a breath sample when an officer asks you to, that your license will be suspended. Now, that doesn't mean that you don't have a right to challenge that suspension in court. But what happens is there's something called a 10-day letter that is sent out, and it does two very important things. First, it tells you when that suspension is going to start, which is something you've got to know, right? And then second, it's going to give you a 10-day window from the date of the letter, not the date you get the letter, but the date of the letter, 10 days to go file something in court saying, hey, judge, this suspension is unfair because the officer did not have probable cause to ask me to blow. What you're doing is you're getting a judge to review that officer's probable cause. Why is this important? It's important because you might well win. The judge might not agree with that officer. The officers aren't always right, after all. And the judge may say, there just wasn't reason enough to believe that this person was intoxicated behind the wheel. And if the judge agrees with you on that, that does two very important things. First, your license suspension for the implied consent violation goes away. And then second, your DUI charge necessarily goes away altogether, because if a judge finds that there was no probable cause to ask you to give a breath sample, that means there was no probable cause to arrest you and charge you with DUI. Now, whenever you get one of these 10-day letters, it is important to move quickly because, as you know, our postal service doesn't work like it used to. We are seeing instances where people's 10-day letters show up at their door sometimes on the 9th day or even the 10th day.
Want to know more? Like and subscribe to our Eichelberger Law Firm channel to check out more videos on this and other important legal topics.